Good day, our esteemed listeners, viewers, subscribers, and the listeners of Ascent Radio, and welcome to another interesting, intriguing, amazing, and wonderful edition of Let's Talk with Ascent Litigation. I remain your host, yours favorite, Barrister David Njoko Ono, and today we are going to have another interesting, wonderful, and intriguing, exciting topic for discussion. I hope you're ready because today's slaps will be very dirty. We are going to ensure that we slice all in our content, dot all the I's and cross all the T's, in ensuring that you understand the law, and that is what we do here in Ascent Litigation. Today's topic will be no different from the previous topics, which have been inciting and interesting topics. Today's topic will be the rights of employees in the workplace. Did you hear that? The rights of employees in the workplace. And as usual, we'll be beginning with a story. Now, today our story will be featuring our very good friend, Mr. Nuru. Now, Mr. Nuru happens to work for his uncle. His uncle invited him over to the city to work for him at his factory, and then his uncle did not give him any contract of employment, but told him just to work and then he will be paid. So Mr. Nuru was supposed to be paid, according to the agreement, he was supposed to be paid 50,000 naira, but the uncle decided to only pay him 40,000 naira as cash, and the 10,000 naira remaining, the uncle decided to use it as expenses for his lunch, because the factory has a canteen, and it's a policy in the factory that all employees must eat their lunch from the factory's canteen, and that money will be deducted from their salary, which is the cumulative amount of 10,000 naira. Now, Mr. Nuru, at a certain point in time, after working for the firm for the factory for over 5 years, he's now asked that his services is no longer needed because the company is downsizing, and he was informed 3 days to the date he was issued a sack letter. Now, Mr. Nuru has approached us as his friends and wants us to give him advice in this regard, and it is based on the story of Mr. Nuru that we will be dissecting and giving an exegesis of today's topic: rights of employees at the workplace. Now, did you know that the basic law that governs the relationship between employers and employees is the Nigerian Labour Act? And the Nigerian Labour Act covers the entire federation, the 36 states of Nigeria, including the Federal Capital Territory. And it is the primary and basic law that governs the relationship between employers and employees. Now, under the Nigerian Labour Act, it provides that, number one, the first rights of every employee is the right against forced labor. That is to say, no employee should be forced to undertake any work. If it is not within your work description, which is covered under your contract of employment, then you should not be forced to take up that job. Or even nobody should be forced as being mandatory that you must take up a job. That is to say, the state government cannot create a ministry. Let's say that there is a reduction in primary school teachers in the state, and then the state government will not create a policy and say that every graduate between year 2022 and 2023 that are indigenous of these states must work under the Ministry of Education to be employed as teachers. The state government cannot have such policy because that will amount to forced labor. And so the Labour Act prohibits forced labor. The Labour Act equally ensures that all agreements, contract of employment, must be in writing. That is to say, before you can be engaged by your employer must provide contract of employment for you. The contract of employment must state the name of the employer and the name of the employee. It must constantly state the nature of the job. By nature of the job, we mean the job description. What are the things you are supposed to do as an employee in that company? Also, it must state the wages you are to be paid. Now, in setting the wages, it must not state that you must be paid 50,000 or 200,000 or 100,000. The amount must not be stated, but it must be clearly stated that you will be paid for the services you render to the company. Now, if the services you render is to be paid by way of salaries, by way of wages, weekly wages, or by way of monthly wages, or by way of commission, it will be clearly stated there. And this is because you don't have to dabble between when you are being paid and when you are not to be paid. You should know that after the end of the month, you have to be paid your wages. And if you're knowing that your wages is coming as salary or is coming as a commission, if it's coming by commission, it has to be stipulated that you must reach a particular target for you to be entitled to certain amount as commission. But for your wages, it has to be steady, it has to be stipulated, it has to be firm in the contract of employment. So these are the 4 things your contract of employment must have. It must have your name and the name of your employer. It must have the nature of your job. That is what you are supposed to do as an employee. It must have the wages you are supposed to be paid. And equally, if this is not mandatory, it can have the duration of your work. If it is a work that is time bound, let's say it is a contract job for the construction of a public road, and it's supposed to last for 3 years, and then you're not employed as a staff for that company, construction company, for the purpose of construction of that road. In the contract of employment, it has to be stated that you're not a full-time staff of the company, but you're only employed for the purpose of the construction of this public road, which is to last for 12 months, 24 months, 36 months, or whatsoever is the duration. It has to be clearly stated there. So if your employment is time bound, then the duration must be stated. Where the duration is not stated, then you are automatically a bona fide staff of that company, and as such, your contract of employment lasts as long as the company exists. Now, the implication is this. If, for example, David Construction Limited decides to engage you for the purpose of constructing, let's say, Lagos-Kaduna Expressway, and it's supposed to last for 36 months. But in your contract of employment, it's not stated there that the duration of your work is only within the period when this road is to be constructed, which is 36 months. If it is not stated there, that contract of employment automatically means that I am a bona fide staff of that called benefits of regular staffs of the construction company. Now, this is where the concept of contract staffs come into play. So as a contract staff, you should know that your job duration is only within the period when your services is needed, and it must be stated in your contract of employment. Now, the third right that is covered under the Nigerian Labour Act is that you have a right to fair wage. Now, what is fair wage is dependent on certain factors. Factors like factors of location of your factory. If your factory is located in a rural area, okay, that is to say, if it's located in the hinterland, in the villages, then definitely you are not expecting such fat wages as those who are located in the urban centers, especially if the company has accommodation provision for you as an employee. You understand? So these are factors that the company is going to take into consideration to determine what is fair wage to be given to an employee. Now, you should note this. Now, when your company decides to pay you your salary, and it's agreed in your contract of employment that you're to receive XYZ, let's say you're to receive 50,000 naira as fair wage. Now, it is unlawful for that same company to now say that it has to deduct certain amounts from your salary to cover expenses that is not captured in your contract of employment, to cover expenses like accommodation, cover expenses like feeding. Let's take, for example, Mr. Nuru in our story. His uncle decided to deduct 10,000 naira, not just from him, but from every other employee in his industry, on the basis that that 10,000 naira will cover for their lunch for the month. Now, it is illegal, it is wrong under the Nigerian Labour Act for an employee to determine how the employer, for an employer rather, to determine how the employee is to spend his wages or salaries. Now, If you're being paid 50,000 naira, it is your right as an employee to determine how to spend that money with respect to accommodation, with respect to feeding, with respect to clothing, or whatsoever. It is not in the place of your employer to determine for you how to spend your money by stating that there is a canteen in the factory or in on the company for which every staff must eat from that canteen. And so expenses for the feeding of each staff has to be deducted from their salary, or that the company provides accommodation, and as such, certain amount of money should be deducted from your salary every month to pay for the accommodation expenses. That is wrong. Okay, it should be voluntary. If the employee opts to have an accommodation within the staff quarters of the company, then it is the employee that should have a separate tenancy agreement with the employer as to how much he is to pay and when such rent is to be paid, if it is annually or if it is monthly or if it is quarterly. It is not in the place of the employer to determine for the employee. Also, we have the right to be paid wages at least monthly. Now, under the Nigerian Labour Act, it is wrong, it is illegal, it is unenforceable if you have a contract of employment where it is stated that your wages or your salaries is to come quarterly. That is to say, the company is only to pay you after the end of 3 months. Every 3 months, the company will not pay you. They will accumulate. They will accumulate rather your accumulated wages and salaries for the past 3 months, and then they pay you in bulk. That is wrong. The law provides that as an employee, you are entitled to at least monthly wages. Okay? If it is coming as salaries. If it's coming as commission, you should be entitled to as many times as you have fulfilled your obligations for which that commission is to be given to you. So your employer is not your banker for the purpose of saving your salaries for you. So if you have a contract of employment that says that your salaries is to be paid only after every 3 months, that is quarterly, then that contract of employment is unenforceable in law. So even though you sign that contract of employment, when you get to court, the court will declare such contract of employment null and void, and will rule your relationship between your employer and your employee to be governed by the general principles governing labor matters in Nigeria, which provides that you have to be paid monthly and not quarterly. Also, you should note that where an employee mistakenly overpays an employee, where an employer mistakenly overpays an employee, you're supposed to receive 50,000 naira at the end of the month, and your employer mistakenly sends you 70,000 naira or 100,000 naira at the end of the month. Now, that is you being overpaid. Now, your employer has a limited period of 3 months to deduct such overpaid salaries. Okay, that's the overhead, the excess rather paid to you. He has no less than 3 months to deduct that excess from your future salaries. If it exceeds 3 months and he is yet to deduct such the excess paid to you from your future salaries, he is now barred, he is now estopped, as we call it in law, from any deduction of that overpayment made to you from your future salaries. I hope you got this. Now, this is what it means. Let's say Mr. Nuhu, who is supposed to be paid 50,000, his uncle now mistakenly paid him 70,000 at the end of the month. Let's say the uncle paid him 70,000 as at January. The uncle has February, March, and April within these 3 months to deduct the full sum of 20,000 naira from Mr. Nuru's account. That is from his subsequent salaries, which is to cover for the overpaid amount of 20,000 naira. If the uncle fails to deduct in full these very salaries after 3 months from the date the overpayment was made, the uncle, being the employer, is now restrained, is now restricted, is now stopped under the law for making such deductions of overpayments made to Mr. Nuru in future salaries that Mr. Nuru is entitled to. I hope that is clear enough. Also, every employee has the right to safe and healthy workplace. But this is what do we mean? If you're working in a construction company, it is the duty of your employer to provide for you your safety gears, which otherwise known as personal protective equipment. Your headgear, that is your helmet, your work boots, your overall or coverall, as engineers we call it. It is the duty, your hand gloves, your goggle. It is the duty of your employer to provide for all this. It is not the duty of the employee. So, assuming in the situation where the employee is now told you are the ones to provide for your personal protective equipment, okay, and it happened that the employee is unable to provide that for himself, and there is a workplace accident which could have been prevented if these PPEs were with the employee. Now, the law is that cannot amount to negligence on the part of the employee. The employer is still responsible for the welfare of that employee. And as such, he cannot assume himself from the liability of paying damages, monetary damages and otherwise, to the employee for the harm done to the employee as a result of workplace hazard. So that is the position of the law. So your personal protective equipment, when you're working in a construction company or in a company that has, or in a workplace that has to do with that the workplace hazard is high, it is the duty of the employer to provide your personal protective equipment, and it's not the duty of the employee to provide them. It's just like saying members of the Nigerian police force, it's the duty of the Nigerian police officers to provide their uniforms, their boots, their guns and bullets. No, it is the duty of the employer, being the Nigerian government, to provide all this. That is how it is the duty of your employer to provide what you need for your workplace, which includes your personal protective equipment. Also, every employee has a right against discrimination. So no employee should be discriminated on the grounds of tribe, on the grounds of color, on the grounds of religion, or on the grounds of ethnic nationality. No. The law provides, even under the Section 42 of the Nigerian Constitution, provides that every Nigerian is equal in the sight of the law, and as such should not be discriminated upon, whether on the basis of tribe, whether on the basis of ethnicity, or whether on the basis of religion or color. You cannot be discriminated upon. So let's say, for example, that one has a deficiency of albinoism in a workplace. The management of such workplace cannot say that they cannot promote this person to the position of managing director simply because of his skin disease, being an albino. That is highly prohibited under the Nigerian Labour Act. Also, the Act provides that every employee has the right to join a trade union. Now, what this means is that any employee of a workplace, if there is a trade union or a trading body, okay, that governs workers under such industry, you are entitled, you are not restricted by any means to join such trade union. Now, trade union are pressure groups for workers, okay, that look after and cater for the welfare of workers. So if you decide to join a trade union that is that covers your work description, let's say you work under the electricity industry and there is Senior Staff Association of Electricity Workers, and you want to join them, your employer cannot say, because he is a private entity, you cannot join a trade union. No, trade unions are not just meant for staffs in the public sector, that is in government offices and institutions. They are both for public and private sector. So if you are a lawyer and you work under a private establishment, Your employee, yeah, I cannot say that because is a private entity, you cannot join the Nigerian Bar Association. Likewise, medical doctors, likewise, engineers. They have Society of Engineers, which are pressure groups and trade unions for the purpose of galvanizing and harmonizing workplace relations within the engineering field. So you cannot be restricted or restrained from joining a trade union by your employer simply because he is a private entity. Not at all. And also, the law provides that in whether a public or a private entity, where the number of employees are up to 20, that is from 20 and above, those employees can come together for the purpose of forming a trade union. Did you hear that? If you are in a workplace and you're up to 20 as employees, you have the right to galvanize yourself, organize yourself, that is what we mean, and then form a trade union, okay, or an association. It is within your rights. And your employer cannot say because it's a private entity, you cannot establish your own trade union. It's not possible. So that is what the law provides. Also, as an employee, you have a right to leisure and recreation. Now, the law is simple. Where you work in you're in a workplace that the working hours is 6 hours and above, you are entitled to at least 1 hour break period. That's the position of the law. So if you work in an establishment where the working hour is from 6 a.m. to 12 noon, or 6 a.m. to 2, or 8 a.m. to 4 or 5 p.m. in the evening, as long as it's within 6 hours and above, you are entitled to at least 1 hour break period. So, for example, if Mr. Nuru in our story, who works for his uncle's industry, and he works for 12 hours from 7 a.m. to 7 p.m., he is entitled to 1 hour, at least 1 hour period of break. And so the uncle cannot say, no, because you're my nephew, you're only entitled to 30 minutes break period. Or because the workload in the industry is very much. So today, we have to reduce our break period from 1 hour to 30 minutes. No employer has the right to do so. As long as the working hours each day is beyond 6 hours, every employee is entitled to at least 1 hour break period for leisure and recreation. Also, every employee has rights to annual leave. If you have worked for a continuous period, and I take that word, continuous period of 12 months, that means you had no reason to take leave, maybe sick leave, or you have personal needs for which you will be out of work for a week, 2 days, 3 days, 4 days. You have worked continuously for a period of 1 year, that is 12 months. You are entitled to at least 12 days of leave. Now, that 12 days of leave is excluding days of public holidays and weekends. So, if you worked from January to December continuously, you are entitled to at least 12 days leave, annual leave, and you are to be paid for that annual leave, inclusive of your monthly payment. So, your establishment should have something they call allowances for annual leave, that period, so as to encourage you when they come back to be revitalized to continue with your workplace. And also, interestingly, we have the maternity and paternity leave rights. Some persons will be surprised at this point. What do you mean by paternity leave rights? Now, under the Nigerian labor law, we have the maternity leave right. That is to say, if you are pregnant as a lady in a workplace, 2 months to your delivery month, that is from your 7th month, you are entitled to maternity leave. And 2 months after your delivery, you are entitled also to continuous maternity leave, which is a cumulative period of 4 months. So from 2 months to the date of your delivery, you are entitled to 2 months maternity leave. 2 months after the date of your delivery, you are entitled to another 2 months maternity leave, bringing it a cumulative period of 4 months maternity leave for every pregnant lady that is an employee. Now, if you're a man, though the Nigerian Labour Act does not have provisions for men or fathers who their wife just gave birth as employees. But under these various state laws, civil service rules rather, it's now made compulsory that men who are employees and whose wife just gave birth, they are entitled to period, it differs. Some states has period of 10 days paternity leave. That is 10 days after the birth of your child. You are free to go bond with the child so that to create that very union. Let it not be as though it's just the mother that the child will be seeing for the first 2 months after his birth. You should have the time to bond with your newborn baby. So 10 days within the first 2 months of the birth of your child, as a man, being an employee rather, you are entitled to at least 10 days paternity leave. And if it is in the federal government institution, you are entitled to 12 days paternity leave. 2 months, within 2 months after the birth of your baby. Also, every employer is entitled to privacy. Now, what this means is that it is wrong for your employer to insert security cameras within the workplace without informing you as the employee. I hope you got that. It is wrong for an employer to insert security cameras within the workplace without informing you as an employee. Some employers goes as zealous as inserting CCTV cameras in restrooms of their workplace, especially banks. And it's wrong because that's infringes on the privacy, right to privacy of their employees who may want to have some quiet time. So if you are an employer and you want to insert CCTV camera within your workplace, you must inform your employees. So your employees are aware that they are being monitored. So that helps to even checkmate the activities of your employees and make them put them on the know, so as to be very active within the workplace and not just to be redundant or not to constitute themselves as nuisance within the workplace, knowing that they are being monitored. But they have to know. Now, the one of the last rights we are going to discuss is the right to notices of termination of contract of employment. Now, as we said earlier, when you're being engaged, you are entitled to a contract of employment. That contract of employment must be issued within 3 months after your engagement in the company or in that establishment. Now, if your employment is to be terminated, contract of employment is to be terminated, you are equally entitled to notice. Now, the duration of the notice is dependent on how long you have worked in that establishment. For example, if you have worked in an establishment within 3 months or less, you are entitled to at least a day's notice. That is, even though you have worked in a place for just a day, you are entitled to at least a day's notice of termination of your contract of employment. If you have worked in an establishment for a period of 3 months but less than 2 years, you are entitled to at least 1 week notice of termination of your contract of employment. And if you have worked in an establishment within 2 years but less than 5 years, you are entitled to at least 2 weeks notice of termination of your contract of employment. And if you have worked in an establishment beyond 5 years rather, you are entitled to at least 1 month notice of termination of your contract of employment. Where these notices are not given and your contract of employment is terminated, such termination is what we call wrongful termination of contract of employment, and you are entitled to damages to be paid. And the court can even go further to construe that the period between which where you were not paid salaries and given a wrongful notice of termination of your contract of employment, you are entitled to the wages because your employment still subsists, because that notice you were issued is a wrong notice. So it is not recognized under the law, and as such, what the law will still recognize is that your contract of employment still subsists even after you have been disengaged wrongfully by your employer. So you're still entitled to that period, wages for that period within which you were issued termination of your notice of termination of your employment, because such notice was wrongfully issued. So let me take that again. If your employment, you have been employed for 3 months or less in an establishment, you are entitled to at least a day's notice of termination of your contract of employment. If you have been employed for an establishment within 3 months and 2 years, you are entitled to at least a week's notice of termination of your contract of employment. If you have been employed within the period of 2 years but less than 5 years, you are entitled to at least 2 weeks of notice of termination of your contract of employment. And if you are employed within an establishment for 5 years and above, you are entitled to at least 1 month notice of termination of your contract of employment. I hope with this you have been able to gather enough arsenal to put in your canons as employees, knowing your rights. And then tomorrow, you can walk to your workplace with your shoulder high, knowing that you know your rights, and then you want to enforce your rights when the need arises. As usual, we always want to hear from you. So please, get us your feedbacks. Please put your comments in the comment section of whatever streaming platform you're listening to us. And as usual, we will be prompt in replying your comments, suggestions, and feedbacks to us. Until we come again your way next week, remain blessed, and as we say, shalom for staying tuned to Ascent Litigation. Bye-bye.